Back to our channel or legal talks. In this video, we are discussing a key board resolution under the Companies Act 2013, approval for granting stock options to identified employees where the grant equals to or exceeds 1% of company's issued capital in any 1 year. Certified copy of the board resolution related to ESOP grants exceeding 1% of issued capital. So where it is equal or 1% of issued capital, then separate resolution with members' approval is required. So this resolution is critical from both a legal and governance perspective, as it requires prior shareholder approval. Where you are a company secretary, startup founder, or compliance professional, this guide will walk you through the certified format, legal basis, and best practices to follow. So this is on the letterhead of the company. We are talking about the certified true copy of the resolution passed by the board of directors. This board will approve and recommend for members' approval. So here you will write your company name, and at their meeting held on, you will fill the date and time and registered office address. So subject to approval of the members, because it has to be approved by members. Shareholders approval is a mandatory. Subject to approval of the members of the company, approval for grant of options to the identified employees during any 1 year equal to or exceeding 1% of the issued capital of the company at the time of grant. Very important to understand. So approval for grant options, ESOPs, to the identified employees during any 1 year equal to or exceeding 1% of the issued capital of the company at the time of grant. Hope we are clear. So the chairman informed the board it is required to seek separate approval in case the company is granting options to the identified employees during any 1 year equal to or exceeding 1% of the issued capital of the company at the time of grant. So chairman is explaining this is what. Accordingly, the following resolution was proposed and passed by the members of the board of the company. So here description is given. Then we'll come to the resolution. Resolve that subject to approval of the members of the company, pursuant to the provisions of 62(1)(b) and all other applicable provisions of any of the Companies Act 2013, ready with rules framed thereunder, including any statutory modifications, reenactments thereof for time being in force, and in accordance with the relevant provisions of the memorandum and articles of association with the company. Together with the fundamental documents, and it is a listed company or proposed listed company, Securities Exchange Board of India, Share-based Employee Benefits and Security Regulations 2021, that is SEBI, SBEBAC Regulations 2021, and SEBI Listing Obligation and Disclosure Requirement Regulations 2015, that is SEBI LODR Regulations, as amended from time to time and in accordance with such other circulars, rules, regulations, and guidelines issued or that may be issued by SEBI and or other appropriate authorities from time to time, and further subject to other approvals, permissions, and sanctions as may be necessary. The consent of the board of directors of the company, B&E is hereby accorded to create, offer, and grant from time to time options equal to or more than 1% of the issued, subscribed, paid up capital of the company, excluding outstanding warrants and conversions at the time of grant during any 1 year to identified employees of the company in accordance with the SEBI Share-based Employee Benefits and Security Regulations, and the scheme respectively within the overall ceiling options that may be granted. Anyway, subject to ceiling options only. Another resolution resolved further that the company shall conform to the accounting policies prescribed under Regulation 15 of SEBI, Safeguards Employee Benefit and Statutory Regulations, and any other applicable laws and regulations to the extent relevant and applicable in connection with the implementation of this scheme. And these accounting policies are prescribed under Regulation 15. And another resolution resolved further that the consent of the board be and is hereby according to authorize any director of the compensation committee, the NRC designated as a compensation committee in most of the cases. So here we are giving authorization to any one of the director of the compensation committee to sign or execute or submit, acknowledge or endorse applications, deeds, documents, waivers, grant letters, intimations, and such other documents, because this is a big procedure. Applications, deeds, documents, waivers, grant letters, intimations, as may be required or its absolute discretion, as it may deem necessary for notification, administration, superintendence, and implementation of this scheme, and to take such steps, and to do all such acts, deed, things, and matters in this regard, including filing of necessary forms and applications, intimations, and disclosures with concerned authorities, institutions, for the requisite approvals as may be required under the applicable laws for time to time, without being required to seek any further consent or approval from members of the company. Certified to copy. Here is the company name, signature, and then name of the director, DIN number. Thanks for watching. If you found this video helpful, don't forget to like, share, and subscribe for more legal and corporate compliance. Subscribe RR Corporates and RR Legal Talks YouTube channels. This is for the certified copy of the resolution where approval for the grant of options to the identified employees during any 1 year equal to or exceeding 1% of the issued capital of the company at the time of grant. Hope you are clear. First, board will propose and recommend for, board will approve and recommend for members' approval. Thank you.